Good morning, sir. You're Mark Garcia. And Mr. Garcia, we've gone through all this before, but I'm going to go through it again today to make sure we're all on the same page. In cause number 25, DCCR 0120, you're charged with the state jail felony offense of theft of material, copper, and that's from April 7th of 2024. Your indictment alleges you were previously convicted of the state jail felony offense of theft and theft of material on February 22nd of 2022. And then after those were final, it shows that you were convicted of possession of a controlled substance, a state jail felony, and then fraudulent use of possession of identifying information, a state jail felony, September 19th of 2023. What that means is that if you go to trial and you're found guilty and those prior convictions are true, you would be enhanced to a third degree for punishment, which means the possible punishment would be between 2 and up to 10 years in prison. Do you understand?
Yes, ma'am.
And the state has made an offer, if you wanted to enter a plea of guilty at this point, for a 5-year term in prison. You have every right to reject that and have your case set for trial. I just want to make sure you understand what the possible consequences are, what your options are. Do you understand all of that? And do you want to reject that and have your case set for trial? Right, I'll get that done. And so I do want to make sure, Mr. Garcia, that you understand once your case is on the trial docket, I don't typically accept plea agreements unless there's new information or evidence that the parties did not know about. So if you change your mind later and want to enter a plea of guilty, it would be to something different. It would be either open to the court or to something different than 5 years. You understand? Okay. I want to make sure everybody understands that once it's on the trial docket, it's not just to buy some time so you get a better deal, because that's not how it works. Mr. Garcia, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and I can appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right. So, Mr. Lewis, you'll remain on the case and begin preparation for trial, and we'll get it set on the next available trial docket.
May I just, put on the record that we will intend to call Thomas Valentino, the co-defendant, who's already taken responsibility for this case and pled TDC time. I do know his whereabouts up in Round Rock, and I believe Mr. Garcia is guilty as a party, and I will be calling him as a witness.
All right. Thank you. If that changes anything, let me know as quickly as you can. All right. You can go back with the bailiff. Well, we don't really need to change.
We're not changing any.
True to 1 and 3. Do we need to do anything else?
No, Your Honor.
Sentence in accordance with the agreement.
Yes,
Okay.
ma'am.
Good morning, sir. Are you Justin Jacoby Joseph?
Yes, ma'am.
And Mr. Joseph was previously in court. We're here in cause numbers 20-35818 and 20-35476. And Mr. Joseph is on probation in those cases for possession of a controlled substance, a second-degree felony, and evading detention with a motor vehicle, a third-degree felony. Entered pleas of true in each of those cases to counts 1 and 3. In those motions to revoke, I received the updated report as well as some letters of support. Has you both had an opportunity to review all of that?
Yes, Your Honor.
Yeah.
Any additions or corrections to that report?
No.
No, Your Honor.
It's my understanding at that time there was no agreement, but at this time there has been an agreement. Is that correct?
That's correct.
And so, Mr. Joseph, I have here on the tablet some documents in each of your cases that have your signature on them that the state's marked as Exhibit Number 1. Before you signed these, did you go over them with Mr. Lewis?
Yes, ma'am.
And do you understand if I follow that agreement that you've made in these cases, that if I follow it, you'll be waiving or giving up any right to appeal?
Yep.
State tenders number 1 in each of those cases?
Objection.
It's admitted in each case. Anything different with regard to competency or?
No.
All right. So, Mr. Joseph, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 and 3 freely and voluntarily. Find those counts true and find sufficient evidence to find you guilty. And cause number 20-35476, find you guilty of possession of a controlled substance. Sentence you in accordance with your agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. And then in cause number 20-35818, find sufficient evidence to find you guilty, and at this time find you guilty of evading arrest or detention with the use of a vehicle. Sentence you in accordance with that agreement to a term of 6 years in the institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In each of these cases, I'm going to hand you the trial court certifications that shows these were agreements that I followed, so you did waive your right to appeal. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right. Good luck to you, sir. Let's see. John Lamel.
John Lamel.
Good morning, sir. You're John Lamel.
Yes, ma'am, I.
And Mr. Lewis, will your client waive the formal reading of the motion?
He does.
Mr. Lamel, in cause number 21-38857, I have a first amended motion to revoke your unadjudicated probation. Shows that you were placed on probation May 1st of 2023 for the offense of theft of property, a state jail felony, and that was a 3-year deferred probation that's been extended. Is that correct? This motion alleges that you violated your probation. Count 1 alleges that you committed the offense of unlawful carrying a weapon January 2nd of 2026 in Jefferson County. And is that true or not true?
It's true.
Count 2 alleges that you committed the offense of fleeing a police officer January 2nd of 2026. And is that true or not true?
That's true.
Your Honor, the state would abandon counts 3 and 4. 4 and 5. 3, 4, and 5.
Count 6, thank you, Mr. Coleman. Count 6 alleges that you failed to complete the JCDI program as ordered. Is that true or not true? Did you complete the program?
Oh, ma'am, I was almost ready to go.
Yeah, but you didn't complete it.
Yes.
So that's true. Count 6. And then, all right, so did you enter your pleas of true to counts 1, 2, and 6 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Actually true.
I have here on the tablets and documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis?
Ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Any evidence that Mr. Lamel is not competent?
No.
All right, sir, I'm going to find that you entered your pleas of true to counts 1, 2, and 6 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offensive theft. Sentence you in accordance with your agreement to a term of 180 days in the state jail prison. You will receive credit on that for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff.
Thank you, Judge.
Good morning, sir. You're Devontae Savoy,
Yes, ma'am.
and this is 23 DCCR 2038. And Mr. Savoy was previously in court, entered pleas of true to motion to revoke probation to counts 1 through 5 and counts 7 through 15. I have received the updated report. Have you both had an opportunity to review that report?
Yes, Your Honor.
Any additions or corrections?
No.
None from the state.
So it looks, and probation's here. Thank you, ma'am. It looks like the recommendation of probation would be actually for Mr. Savoy to remain on probation, but to go to the cognitive track of ISF with JCDI after. Is that correct? Miss French, what is the state's position?
I have already worked with the prosecutor in the misdemeanor court. He has 2 pending misdemeanors, which would prevent him from going to ISF. But he has enough time for credit for time served on those cases, and that's what he'll be offered in order to dispose of those.
Okay, so you're in agreement with this offer here, or
Yeah.
the recommendation?
Yes.
So, Mr. Savoy, Today's a big day for you because everybody here wants to work with you and give you an opportunity to be successful on your probation. And so I'm going to go along with that, but I just want you to understand that you will not be given this opportunity again. Okay. So what I'm going to do is find that you entered your pleas of true to counts 1 through 5, 7 through 15, freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty and revoke your probation, but I'm not going to do that. I'm going to continue your probation. I am going to order that as a condition of your probation, you enter and successfully complete the cognitive track of the ISF program. It's a 90-day program. It's going to help you with making better decisions, thinking through things better, and things like that, okay? In addition, when you get out, you'll go through JCDI as aftercare, and so that will help you with any drug issues that you might have. So you're going to get treatment kind of for everything across the board so that you can make better decisions and be successful. It's up to you to take advantage of it. Nobody can force you at this point. So you either take advantage of this opportunity or you don't, okay?
Yes, ma'am.
You will be on zero tolerance. That means you cannot make any mistakes. You've got to do everything correctly. This is the last chance. And so you don't get to say, well, I just messed up a little bit. You can't mess up at all, okay?
Yes, ma'am.
You're still on a deferred probation. You still don't have a felony conviction. So I really hope you take advantage of this. Learn what they have to offer you in JCDI and in ISF so that you can move forward with your life and live it kind of like the rest of us. Okay. All right. Good luck to you, sir. You can go back with the bailiff.
Mr.
Good morning, sir. You Derek Schinkel?
Yes, ma'am.
And Mr. Schinkel, in cause number 25, DCCR 1797, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon. That's from October 15th of 2025. The indictment alleges also that you were previously convicted of possession of a controlled substance, a third-degree felony, October 18th of 2016 in Orange County, Texas. What that means is that if you go to trial in this case and you're found guilty, and if that prior conviction is true, then you would your punishment would be enhanced from a second degree to a first degree felony with a minimum of 5 years up to 99 years or life in prison. Do you understand?
Yes.
And I have here on the tablet a plea bargain rejection that you've signed with Mr. Lewis that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty for a 10-year term in prison. You have every right to reject that and have your case go to a jury and let them decide. I just want to make sure you understand what your possible consequences are if you go to trial, what your options are. Do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
Yes, ma'am.
Is there any reason to believe, Mr. Smith, that there will be any change in that offer?
It will never go down, Judge. You got 10 years last time. I only came down to 10. That offer expired today.
So I do want to make sure you understand, Mr. Schinkel, that once your case goes on the trial docket, it's on the trial docket. It's not to buy more time to get a better deal. I will not accept this plea agreement after today. If you change your mind later and want to enter a plea of guilty, it would either be to something either open to the court or to something different than the 10 years. You understand? All right. So I am also going to make the notation on the rejection that I admonished him to the first degree because it was just marked off the second. And so, Mr. Schinkel, Mr. Lewis has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him today and appoint another attorney today who could begin preparation a little quicker. Is that okay with you? So, Mr. Lewis, you're released. Mr. Schinkel, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Okay, you can go back with the bailiff.
Thank you very much.
All right, sir, you're Jesse Griffin. And Ms. Coffin, will your client waive the formal reading of the indictment?
Yes, Your Honor, he will.
Mr. Griffin, in cause number 25, DCCR 1397, you're charged with a second-degree felony offense of aggravated assault with a deadly weapon from August 28th of 2025. How do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Ms. Coffin?
Yes, ma'am.
And do you fully understand them?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number one.
No objection.
It's admitted. Is there any evidence that Mr. Griffin is not innocent other than what we've already gone through?
No, Your Honor.
All right, sir, I'm going to find at this time that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you in accordance with your agreement to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I've handed you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have any questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Coffin. All right? Good luck to you, sir. You can go back with the bailiff.
Thank you, Your Honor.